we can start our meeting as the fourth panel, the theme Electoral Justice. So I'm gonna ask the first person to introduce your paper, which is Leontine Loeber. You have 15 minutes to your presentation.
Thank you very much, and thank you for the organizers of this conference. Let me see if I can share my screen with you. Thank you very much for giving me the opportunity to speak in this panel and this conference. The paper that I'm presenting, or the case study I'm presenting, is still work in progress, but I figured it would be interesting to talk about it anyway. And what I want to talk to you about today is election dispute resolution in the Netherlands. The Netherlands is a very old democracy. We started having elections in 1848, I'm sorry, and we've had our current electoral system with proportional representations since 1917. Sometimes you feel like if you're part of such an old democracy, then everything that needs to be done in elections probably been done, but then suddenly you're faced with new problems and new discussions that have maybe popped up everywhere else in the world, but not in our case yet. And one of those issues is election dispute resolution. So I'm going to take you through my presentation. I'll start with the current system. Then I'll talk a little bit about two cases from the European Court of Human Rights, which made us question our current system. I'll apply the rulings in those cases to the Dutch case. Then I'll talk about the current debate on designing a new system, and I will end up with some conclusions. So the current system in the Netherlands. In our constitution, it specifically states that Parliament in the old composition decides about the integrity of the election and the admissibility of new members. There is no judicial involvement in that process at all at the moment. It's completely put down with the parliamentary committee. Before that, the Electoral Council is the organization that actually sets the results of the vote, and voters can lodge complaints in the polling station on the evening of election and during the meeting of the Electoral Council where these results are announced. The Electoral Council can decide to hold a recount or a partial recount, but they don't have the ability, as some other countries have, to say a revote is necessary. So if there's a lot of complaints about missing ballot papers or things that actually cannot be solved with a recount, the Electoral Council can note those, but cannot actually say we have to have a revote because the elections were not done in a fair way. After this meeting by the Electoral Council, the minutes of the meeting, including possible complaints by voters, are sent to the Credential Committee of the Parliament, which then goes through these meeting minutes and also goes through all the forms from all the polling stations. And then the Parliament can decide to hold a partial recount or a partial revote, or if problems are really large, a full revote. What are the reasons behind the system? Well, when this was introduced in 1917, they stressed the separation of powers, and they said if we involve judges in the political process of determining the outcome of elections, well, judges will have a say over the composition of Parliament, and we don't think that's in line with the separation of the powers. But a very large issue was also the speediness of the process. In the current Dutch system, within 10 days after the elections are being held, the new parliament takes seat. If you have that very speedy process, then you cannot involve a lot of actors in it, and you don't have a lot of time for court cases and hearings. So the main benefit of the current system is that speediness and the clear results that are announced quite quickly after the elections. But as I said, there's no judicial redress possible against the election results and the electoral process from the day of elections. There is a couple of cases which can be brought before judges, but they only see on the preparation phase of the elections. So if voters are not on the voter list, they can go to a judge, and also political parties that are not put on the nomination, or candidates that are refused from the candidate list. Those kind of decisions you can appeal, but everything after that is non-appealable by the court. So, like I said, we've had the system for quite a while now. So what made us rethink this? Well, there's two quite recent rulings from the European Court of Human Rights. The first one, I'm not going to try to say the name. I've tried it a couple times yesterday, but I keep tripping up. But it's a case against Belgium. It was ruled in 2020. And in Belgium, it was the case they have a district electoral system, and all the parliamentarians from that district are involved in the decision whether or not somebody is admissible to the parliament. And a member brought this to the court, and the court said, the court didn't necessarily say you cannot have the final authority about the composition of parliament in the hands of parliament, but they did say there's 3 criteria you have to meet in order to have a fair and appealable process. The first criteria is that there are sufficient guarantees that the decision-making office is impartial. The assessment criteria to settle dispute must be sufficiently defined in law, and there must be sufficient guarantees for fair, objective, and reasoned decisions which are accessible and foreseeable. Well, in the Belgian case, didn't meet those criteria because the members that decided on the admissibility of other members were members that were at stake at the same district election. So basically, you had to rule about your own election if you were ruling about somebody else's admissibility. So the court said they didn't even meet the first criterion, and then they also failed to meet the second and the third one. This decision was upheld, or even like slightly worked upon, in the 2024 decision against Iceland. There it was the new parliament deciding on the admissibility of the election or the fairness of the elections. The court once again said there were insufficient institutional and procedural safeguards against political and partisan decisions in parliament. So they said this procedure you have is not protected enough against parliamentary political use. So it could be used to keep people out of parliament because you don't like the political party they're representing. And they also said that the criterion that which was used in Iceland, that irregularities had to have consequences for the outcome, was very vague because it didn't say what was considered a consequence for the outcome. So when we apply those 2 rulings to the Dutch case, our procedure is quite similar to the Belgian and the Icelandic procedure. Even though it's our old parliament deciding on the new members, in the Dutch system, a lot of times people that are sitting in the old parliament and parties that are in the old parliament are also candidates for the new parliament. So you can probably argue that they're not objective and impartial to the outcome of that election. Also, neither the Constitution nor the electoral law gives any rules on how disputes must be handled by the parliament. And there's no criteria for the parliament to test whether a recount or a revote should be called for. So basically, we don't meet all the 3 criteria. So the conclusion, and that's also the conclusion that's been drawn by the Ministry of the Interior, is that the current Dutch system is not in accordance with the rulings and thus not in accordance with the European Convention of Human Rights on this area. So what is currently going on in the Netherlands? Well, there's plans to design a new system. Well, it first means we have to change the constitution, which is a quite lengthy process. But then also you have to know what kind of system you want to have in place. And I thought it would be interesting to present the 5 main questions, I think, that are debated when you are debating this kind of reform. The first question is, who can complain? I mean, internationally, you see some systems where only candidates can complain about the outcome of the elections if it hinders their election. Other systems allow all voters to complain. In the current Dutch system, all voters can complain to the Electoral Council. And you could say that every voter has a stake in the outcome of elections. So I would argue that it would probably fit the Dutch system the best to have a system where all voters can complain if they feel that the elections were not held in a free and fair manner. Then another issue to decide is what type of irregularities can be put forward. Like I said, one of the main advantages of the Dutch system is the speediness of the process, and we don't want to lose too much of that. That also means you would have to limit the type of irregularities that can be put forward in order to prevent a lot of court cases about small things that probably won't have a lot of effect on the elections, or things that could have been put forward earlier in the process. So you don't want to have another discussion or another court case on the registration of candidates or on political parties, because you have had the opportunity to have those cases heard earlier in the process. So I think you should limit it to things that actually influence the outcome of the elections. A question that is hard to decide is how much of the electoral campaigning should be eligible for complaints afterwards. So if a party feels that it wasn't given enough media time, is that something that you want to have only complained about afterwards, after the results are in? Or is that something that should be brought up earlier in the process? Then in the Netherlands, a big question, and the question that gets the most attention, is who should decide these complaints. Like I said, the European Court of Human Rights didn't specifically say that it couldn't be the parliament, but it had to be more formalized, and the procedure had to be more clear. But because of our system, if you look at these three criteria from the court, I don't think that we can have a system in the Netherlands where the parliament is involved and it's still away from political influence. Because I think whenever you involve the parliament as a final decision maker, then there's the danger of political decisions. So then you have a couple of other options in the Netherlands. You could put this into a special court, as some countries have done. But we don't have a lot of tradition in the Netherlands of having special courts. We also don't have a constitutional court. So there's not really a clear specific court that could be used. The other decisions in the electoral process at the moment are taken by the administrative division of the Council of State. So in the debate, that's currently the most mentioned option, because they already decide on a voter list, on party registration, and on candidates. So they probably are most equipped at the moment to decide this. The main issue with this is that the parliament is excluded from administrative law. So you would pull parliament into the administrative law system in the Netherlands, which would be a very big breach with the way our separation of powers at the moment is being set up. Then a question where I think most countries in the world deal with at some point is, how severe should the irregularities be to overturn a vote? You don't want to overturn a vote too quickly. You don't want to have a lot of recounts and a lot of revotes, because there is literature that shows that voters will lose trust in the electoral system if you constantly have to redo your elections. But you also don't want to not do it when there is a clear sign that the outcome of the election is not a genuine reflection of the will of the people. So some form of benchmark should be decided. What is hard in the Netherlands is we have a proportional representation system where the whole country is one district. So you cannot have if you have a criterion for severity, then you really cannot have a partial revote or a recount. A recount should be possible, but a revote would be hard, because it's hard to say if that small area has an overall effect on the vote of the whole country. So that is something that we're still struggling with, to figure out what is the correct benchmark here. And the other problem with the proportional representation is you cannot have a revote in a specific district. And all the other votes already announced. So if you have a revote in a particular part of the country, and they already know what the overall outcome of the rest of the vote is, that can severely influence the voting of those voters. So those voters actually get a a stronger say in the outcome of the election than they might have had before. So that is also a problem, that we don't have the option to have a revote in a specific district. And then finally, of course, the procedure. I don't want to go in too much detail on that, but there's more about this in the paper. But the question is, who decides at what point and who can appeal then? So in conclusion, I think the 2 court cases do mean that the Dutch system needs to be changed. However, lots of questions still need to be answered, and I think it's very difficult to reform this. I think a lot of countries that are introducing judicial review or electoral disputes resolution systems are dealing with this, and the next phase of the paper is to put this case more into the existing literature on this topic, and to see how other countries have dealt with it and what we can learn from that, from the Dutch case. And I think that judicial review in proportional representation systems is perhaps more problematic than in first past the post or other systemic districts, because you don't have the option of having a revote in a specific district. So you always have to take into account what the nuclear option will do with the outcome of your elections. And my final question is also how this will influence trust in elections. In the Netherlands, trust in elections is generally quite high, around 92% in the last general elections. We've seen in other countries that court cases can also be used in a political way by the people who didn't win to cast doubt about the integrity of the process. It can delay results. It can lead to people having to come back to polling stations, and all these things will chip away at that trust level. So even though it would be good to have an impartial judge be able to look at elections, for the Netherlands, it might also mean that for voters, it will influence their trust and maybe cause more doubt about the integrity of the elections than we currently have. And that was it. Thank you.
Thank you, Leontine, for your presentation. Now we're gonna ask Marjorie Marona to introduce your paper.
Thank you. Let me try to share with you. Just a minute. Here we go. Okay. So, hi everyone. First of all, I'd like to sincerely thank you. Thank you all for being here today. And I'd like to extend my gratitude to the EIP Fellow Program for this opportunity to share my research, to engage with this community of scholars. I should also apologize for the late upload of my paper. We are facing the end of the academic term in Brazil, and it has been particularly demanding, so I appreciate your understanding, and I'm very much looking forward to our discussion today. Well, let me walk you through the core points of my study, judging the ballots, candidate profiles, and electoral court decisions in Minas Gerais. Brazil's courts, as you know, have become powerful players in politics and especially in elections. While courts are supposed to ensure fair competition and keep candidates in check, there is a growing concern that the judiciary might also be used strategically by political actors to attack rivals and to shape electoral outcomes. So my research asks, does Brazil's electoral justice act mainly as an impartial guardian of democratic integrity, or has it become a strategic tool in political competition? And to dig deeper, I examine how this dynamic unfolds at the local level, focusing especially on mayoral elections in Minas Gerais, which is a big and politically diverse state in Brazil. Here is how I tackle it. I analyzed mayoral elections in Minas Gerais across 3 cycles, 2016, 2020, and 2024. I built a new data set from electoral court decisions on the rejection of mayoral candidacies. And for now, my analysis is exploratory and descriptive. So I'm looking at who gets their candidacy rejected, why they are rejected, and whether certain political or social groups are more vulnerable to legal challenges. I explore several variables, political factors such as party, ideology, incumbency, and so on. Some local factors, municipal factors, region, size, economic indicators like GDP per capita, etc. And some judicial factors like type of infraction, legal arguments, identity of plaintiffs. So I hope this design helps me to see if legal challenges stem from genuine enforcement or if they are selectively used for political purposes. Here's what I've found so far. Rejections are mostly technical, not moral. Most rejected candidacies happen for technical or procedural reasons. I mean, like missing documents or errors in party registration paperwork, failure to prove eligibility like age or residency. So this accounts for over 80 cases across my data set. And it shows that Brazil's electoral process is heavily bureaucratic. Still, morality-based rejections, like convictions under Brazil's Clean Record Act, they exist and they carry high political weight, even if fewer in number, around 70 or 75 cases. When we look at the 2024 elections, right-wing parties had the highest absolute number of rejections, 19. But their rejection rate was lower because they filled many candidates. Other hand, had fewer candidates overall, but a higher proportional rejection rate, 5.83%, as you can see. That hints at either stricter scrutiny or organizational challenge for left-leaning groups. Also, incumbent mayors rarely get rejected. Nearly 99.34% of incumbents in 2024 elections were cleared to run again. Non-incumbents had a higher rejection rate, so this suggests that incumbents they know how to navigate the legal process. I mean, their political capital helps them avoid legal pitfalls. Even wealthy regions like this region that are very close to the capital of Minas Gerais, Belo Horizonte, which is called Metropolitan Region of Belo Horizonte, and Triângulo Mineiro. In both of them, we saw candidacies rejected for technical issues. Meanwhile, poorer areas like Norte de Minas had higher rejection rates. But surprisingly, some economically disadvantaged regions like Jequitinhonha showed very high candidacy approval. So what does it show? That procedural rejections can strike anywhere, even where institutions are strong. In Minas Gerais, I'm sorry, I think I don't, I just skipped some. I have another finding. I think I just escaped this. Oh no, here we go. So I was talking about this one, incumbents, and sorry, I just talked about the number 4, the main finding number 4, and I don't have it to show you. I'm so sorry, but the numbers are the ones that I just told. And now let me tell you about this main finding, which concerns the professional background. And in Minas Gerais, a candidate's professional background strongly affects the likelihood of candidacy approval. Business people and professionals dominate the candidate pool, and they face low rejection rates. about 2.5%, likely to the better access to legal and financial support. Politicians, however, see higher rejection rates, around 4.7%, because of public scrutiny and issues tied to prior mandates. Military and religious candidates almost never face rejections, possibly because they carefully ensure compliance. Service sectors professionals have moderate rejection rates, around 3.2%, often due to specific documentation requirements like to public employment. Artisans and small business owners face slightly higher risks, around 3.8%, reflecting some bureaucratic hurdles. And rural candidates also have low rejection rates, around 2.4%, but sometimes they struggle with proving residency. The key takeaway is that no occupational groups is entirely immune from legal challenge. However, candidates with prior political mandates tend to face greater risks due to heightened visibility and scrutiny of their past public service. Overall, a candidate's occupational profile shapes their vulnerability to legal hurdles and ultimately influence who appears on the electoral ballot. A few caveats. I should say that so far my analysis is mainly descriptive. I haven't run advanced statistical models to isolate casual effects. The study focus on one state, Minas Gerais, while diverse, it might not reflect all of Brazil. And legal documents sometimes lack detail about political motivations, make it hard to prove strategic use of the judiciary. And data on political pressure or behind the scenes negotiations remains out of the reach. So some takeaways here. The 2024 electoral cycle in Minas Gerais confirms that the greatest barrier to candidacy remains procedural and technical compliance rather than purely moral or criminal factors. However, the enduring relevance of morality-based rejections underscores the ethical considerations remain central to Brazil's democratic integrity. For political actors, legal robustness and administrative precision are no longer mere technicalities. They are foundational pillars of electoral viability. Navigating this terrain effectively will be critical for all who seek to participate in Brazil's democratic future. So thank you so much for listening.
Thank you, Marjorie. Thank you too for the perfect use of time. And then I'm gonna ask Robert Downs to introduce your paper.
Great, let me share my screen. Okay, great. Do you all see the slides? And is it just the slides? There's not the little sidebar thing?
Yep.
Yeah.
Perfect. Okay, so I'll begin now.
Yeah.
I'll just begin timing myself. Oh yeah, so thank you very much for my presentation, or for attending my presentation. Thank you very much for this opportunity to give the presentation. I'm focusing on the effects of judicial ideology, particularly on campaign spending, and then we'll see I've also done a supplementary or a secondary study of corruption broadly defined, and I'll get into that with our next slide. So I just want to go through a quick roadmap. I want to go through where I got the data, that'll be the Supreme Court database, and then how I'm measuring ideology, or rather what ideological measure I'm using. Then I'll go through the theory of how we model judicial behavior that will set up our expectations. The third, I'll just go through some descriptive statistics, which will just show some charts of what's in the sample that I'm analyzing. We'll return to the theory again in the fourth section where I'll lay out my hypotheses, and then we'll get into the regression analyses. There's one predicted probability graph, but we'll get into the predictive statistics that analyzes and gives us some actual insights into what to expect from the data. So again, I'm looking at, and this is a lot of text, I apologize, so I'll do my best to summarize, but I'm looking at the Supreme Court database, and the entire database covers cases from far before 1946, if you use the older data set, but we're looking at cases between 1946 to 2023. It was last updated in October 2024, but we have all the case facts up to 2023. And the format I'm using is we're looking at cases organized by issue and legal provision, including split justice votes. So what this allows us to do is see the directionality of cases, our case outcomes, to individual judicial voting behavior, where these cases came from, how they were treated in the lower courts, how the Supreme Court treated the lower court decision, a whole bunch of different variables. So it lends itself towards hopefully, definitely modeling and hopefully predicting judicial behavior at the Supreme Court level. And again, in this analysis, we're looking primarily at campaign spending. But if you look at how corruption is coded, it's coded as corruption, governmental or governmental regulation, other than campaign spending. I just put that as a parallel study just to see if there are any other interesting effects. But we'll get to that in later slides. And for our ideology scores, I'm using the Judicial Common Space, which was last updated in April 2024. And I can go into how those metrics are calculated, but for simplicity's sake, we can say that judges are placed in a policy preference space where a score of -1 would be the most liberal and a score of +1 would be the most conservative. Just to give you a rough idea, Stephen Breyer, very renowned liberal justice, has a score of around -0.45, and Antonin Scalia has a score of about +0.5. So those are really what we're looking at in terms of ideological extremes. No one is really out towards the -1 or +1 territory. And then we have, again, decision direction. So if we're looking at a case like abortion rights or gun rights or employment discrimination, where we'd expect, so-called liberal justices to have a proclivity to protect minority rights, and conservatives would go in the opposite direction. Issues are typically or decision directions are typically coded as conservative or liberal. But in campaign spending cases, if we look at the code book, we have it as pro-accountability and or anti-corruption in campaign spending. And then again, for corruption cases, it is pro-accountability, or our other direction is the reverse. Now, this I will explain when I get into the sample, because when you're talking about judges and the reverse would imply pro-corruption or anti-accountability, that sounds kind of odd. But when I get into the sample and we look at the cases, some of the landmark cases, hopefully I can make some more sense of that. But before that, we just go into our theory, what we expect in judicial behavior. Essentially, a null model would be that judges only rely on legal principles, the case facts, and the strict rules of constitutional and statutory interpretation. If this model were to hold up, we'd expect that ideology would not be a significant predictor. We'd expect that institutions would also not be have to be a significant predictor of judicial behavior. But if we look at the attitudinal model, and this holds up at the Supreme Court, especially when cases are decided on the merits, especially when there's a significant question that is open to constitutional ambiguity. We see that justices, again, at the Supreme Court level, where they're insulated from the political pressures, they have lifetime tenure, tend to exercise their personal policy preferences motivated by ideology. Then there's the strategic or rational choice model, and there are different variations of this model. I guess one could just think of it as judges, even though they have this unique capacity at the Supreme Court level to exercise their preferences, they are still constrained by the separation of powers, whether that be Congress respond to their decision by making a law, changing the Constitution, or they might have deference to, say, the Solicitor General if they try a case, or other agencies, given their sort of latitude pre the Loeber-Bright decision that overturned Chevron, for example, but they would defer typically to administrative rulings. In any case, we'd expect that when an institutional player is trying one of these cases, there would be some influence on judicial behavior. And then there's jurisprudential regime theory, and this is somewhat like the legal model, but it's not just that judges are using legal principles and precedent to exercise, to be impartial arbiters of disputes, but when there are specific landmark precedents, we'd expect rulings to have a clear delineation of going one way or the other. So for an example, before Roe versus Wade and after Roe versus Wade, we'd expect there to be a sharp shift in how judges are constrained to make decisions on abortion restrictions. And now we just go through our sample. So this doesn't tell us very much, but if we look at campaign spending, you might be wondering, why is our sample concentrating around 2003? And in 1975, we see a little influx. That's because the Bipartisan Campaign Reform Act was passed in 2002, and then we see legal challenges such as McConnell v. FEC after the fact, and then Buckley v. Vallejo was a little bump when litigants were challenging the Federal Election Campaign Act of 1971. So I'll just refer to them by their acronyms. What the FECA did essentially in Buckley v. Vallejo, the court said, okay, there can be limits on campaign contributions, but there cannot be limits on forms of campaign expenditures. So this is more of a regulatory ruling, but it establishes a first regime of how the Supreme Court is interpreting these cases. McConnell v. FEC, when we compare it to Citizens United, which we can view as a more expansive in terms of limitations on campaign finance, McConnell v. FEC was trying to get rid of soft money in politics, and the judges agreed, holding up the constitutionality of the Bipartisan Campaign Reform Act. So again, when we're thinking about anti-accountability rulings, this is where perhaps we can start to shed some light on what that coding actually means. Because in Citizens v. United, if a judge voted for that, less limitations on campaign finance, that would be coded as anti-accountability. Conversely, if we're looking at a corruption case, I believe is the McDonnell case from 2016. In terms of corruption, the justices said that hosting events or arranging meetings between parties is not a form of corruption or fraud, right? So that's not pro-corruption per se, but what it's doing is it's providing some distance or providing limitations on the threshold for prosecuting government officials. So that would be more anti-accountability, and that's how problematic as those codings are. That is how they are coded in the data set. And now we just look through really quickly. I'll just go through our petitioners. Right off the bat, we see that U.S. senators, public interest organizations, and political actors, which tend to be this bucket category, are typically the ones, I guess, appealing in these campaign spending cases. Conversely, when we look at the respondents, it's no surprise. Again, we see an influx of political actors, U.S. senators. We see a prominence of those two sorts of political actors, but naturally we see the Federal Election Commission taking up a bulk of respondents in these cases. And if we look at why the Supreme Court reviewed these cases, this is just another interesting descriptive statistic to look at, because typically when there's some disagreement at the trial level or then at the appellate level, you'll have the parties motion for a writ of certiorari, which is in essence a writ to have the Supreme Court review the lower court decision. But we don't see that in campaign spending cases by and large. Instead, because of the specific provisions of the FECA and the BCRA, these issues are required to go before, at the trial level, a 3-judge panel at the district court, but then the specific provisions listed next to each law provide that there's a direct appeal to the Supreme Court. So because these electoral issues are so important, and electoral integrity is so important in theory, they have a direct appeal to the highest court. And this is what we saw in those previous landmark cases of McConnell v. FEC and Citizens United. Those both reached the Supreme Court on direct appeal. In terms of just judicial decision-making, again, we would expect there to be more room for interpretation in campaign spending cases because they are constitutional questions, right? Campaign spending is a form of political speech, so these entail the First Amendment. Corruption cases typically fall in the realm of economic activity. And this is justified if we look at just the legal provisions that were at issue at the Supreme Court level. So typically with campaign spending cases, we're looking at the constitutional amendments, so typical at the First Amendment, if not some construal of the Constitution at large. And if we look at actual declarations of unconstitutionality, again, we're typically litigating the FECA or the BCRA. So if there's going to be any declaration of unconstitutionality, it is by and large going to be at the federal level. And the reason for this, again, if we look at Buckley v. Vallejo, the Supreme Court upheld certain limitations on contributions, but then struck down limitations on expenditures. So that's why the majority of these rulings tend to be affirmed in part and reversed in part. And this is why we don't see such central pieces of campaign spending legislation being struck down entirely, but typically modified internally by the court. And really quickly, I'll just go through outcomes of our most common players in these cases of the most prominent parties. And these don't tell us very much. They just tell us when one party wasn't in the case, the proportions of if they prevailed or not. But this doesn't tell us the actual direction of the case. So while the FEC might win the majority of the time, when it is a petitioner in a case, we don't know if these rulings are pro or anti-accountability in the end. Same thing for US senators and same thing for political actors. But since these are our most prevalent parties, we just want to see the breakdown of in terms of their own success, if they prevail or not. And now we look at the case level. We see, again, in campaign spending, a majority of the decision directions tend to be pro-accountability, tend to push for more limitations on campaign spending. We look at the justice level, we can see that the proportion holds up. When things start to get interesting is when we split it up by ideology. And again, this doesn't tell us anything predictively at the outset, but we can at least somewhat discern or deduce rather, that when liberal justices have a say, when liberal justices get their way, when voting on a case, you'll have a pro-accountability outcome. And when conservative justices are involved, they will tend towards a more anti-accountability or more lenient outcome. And finally, this is the last descriptive statistic. Every judge has their own discrete ideology score, but I've just put them in bins so we can see our spread. And we can see just that there's a good variance of ideology on each side. So we shouldn't be worried about bias in the sample when we're measuring ideology, and that hopefully we'll get some good representation of liberal justice and conservative justice behavior and of the justices as a whole. So I will go quickly through the hypotheses. Again, if the legal model holds up, we won't expect ideology to have any influence. We won't expect institutions to have any influence. Judges are impartial arbiters of disputes, and they will come to their own conclusions just through legal precedent and statutory interpretation. If the attitudinal model holds up, we'll expect justices with higher conservative ideology scores to favor anti-accountability rulings, and vice versa for liberal justices. And then I included a sub-hypothesis that's as judges' scores become more conservative or more liberal in one direction, they'll be more sensitive to, say, the risk of corruption. But at the very least, we'll see some asymmetrical effect within justice camps of how they decide these cases. Now, the strategic model, we're just seeing if the role of Congress, so say if a US senator is party to a case, or if a regulatory agency like the FEC is party to a case, we will see some definite, or at the very least significant, modifier of judicial behavior. And then I included just a polarization. So post-Roberts courts, we'll see ideology has an even stronger sway than in less polarized times of the court. And finally, jurisprudential regime theory. We're going to look at Buckley and McConnell and then Citizens United to see if that does hold up and to see if there's a shift in any of these regimes of leaning towards anti or pro-accountability rulings. So I know I have about a minute left. I'll just go very quickly through these analyses. So what we see is that justice's ideology is very significant. And again, this is just a regression model run with two variables, but you'll see this holds up consistently as we move through testing our hypotheses. And it's not just significant, but it shows what that pie chart shows, which is the more conservative a justice is, so the more their ideology score goes up, the more likely they are to reach a anti-accountability outcome, which is coded 2, and the anti-accountability is 1. So justice score goes up, your decision direction goes down. That's a negative relationship. That's what we see here quite strongly. If we break it up to test for our asymmetrical effect, we see that this is primarily happening on the conservative side of the scale. Liberal justices, you could either say that ideology does, I guess just for the sake of time, we could say ideology is not a factor in liberal justices. So you have very liberal justices at times making anti-accountability rulings and more moderate liberal justices making pro-accountability rulings. Conservative justices, it seems the more conservative they are, the more likely you are to get an anti-accountability ruling. Now we just look at the strategic model, and we just want to point out when the FEC is a party, we are significantly more likely to have pro-accountability outcomes. Same thing if a US senator is involved in a party or a political actor, again, broadly defined as a candidate. at any level, as a political organizing committee, as a town committee, etc. And this is our pre-post Roberts analysis. So post Roberts Court, we actually see that the more conservative justices become, the even more likely they are to issue anti-accountability rulings. So that pattern holds up, but at the extreme conservative ends, it becomes even more consistent in the post Roberts era. And finally, we have our jurisprudential regime theory, which we see no significant variation in the Buckley v. Vallejo and McConnell v. FEC rulings, but which I think is perhaps an intuitive but nevertheless an interesting finding. We seem to be in a citizens united regime where judges have a more, will issue more lenient anti-accountability, just because that's how it's coded, rulings on cases. So the legal model does not hold up. And which I think is pretty rare for something like this, we have support for each one of our hypotheses. So with that, yeah, I'll finish there. I know we'll take questions after the fact, but I went a bit over time, but I'll stop it there. So thank you very much.
Thank you, Robert, for your presentation. It was a really great presentation. And then I'm gonna ask to Maximilian Blasnik to show your paper.
Thank you very much. I will try to share my screen. I hope you can see it now. Yeah, perfect. So yeah, hello everyone, and thank you very much to the organizers for giving me the chance to speak at this year's Electoral Integrity Conference. Today, I want to explore a crucial feature of constitutional democracies: the balance between the protection of individual democratic rights with the need to ensure stable and functioning state institutions. At first glance, it may seem obvious that citizens should have legal protection for their right to vote. But when we look closer, and we have already heard that earlier, we discover significant conflicts between two competing principles: the individual right to participation and the legal need to safeguard stable and functioning state institutions. This tension is far from new. Legal scholars have long struggled to categorize electoral rights clearly. Georg Jelinek, a public lawyer, called the right to vote paradoxical. Legal theorist Hans Kelsen described elections as a unique point of contact between state and society, a space where pure legal categories tend to break down. Why is this? Because electoral law operates in two dimensions. As objective law, it structures our political system and legitimizes democratic institutions. As a subjective right, it guarantees each citizen's participation in democracy. Often these two dimensions complement each other, but sometimes they clash, especially when it comes to judicial electoral protection. How can legal systems strike a fair balance between protecting individual rights to participation and preserving the stability of democratic institutions? To explore this, I will focus on Austria's electoral system. It offers a compelling example, not least because of its deep historical roots. I will proceed in 3 steps. First, I will take a brief look at these historical origins of electoral rights protection in Austria. Second, I will outline how the current Austrian system works. And finally, I will assess this model in light of European human rights standards and conclude with some broader reflections. Austria's dual approach to protecting electoral rights dates back to the late 19th century. In 1867, the Habsburg monarchy introduced a progressive catalogue of fundamental rights, including political participation at the local level. What made this system remarkable wasn't only the rights themselves, but the creation of a specialized court, the Reichsgericht, which allowed individuals to bring claims for violations of their rights. This was a major innovation in European constitutionalism back then. The Reichsgericht soon had to rule on electoral participation. Over the decades, it decided hundreds of cases, mostly dealing with voter registration. Who gets on the electoral roll, who doesn't? But tensions quickly emerged between judicial protection of rights and political control of election results. A famous example is the so-called Upper Austrian landowners affair in the 1880s. In the case, some voters challenged the inclusion of certain individuals to the electoral roll and brought the question to the Rijksgericht. The affair became politically explosive because Parliament had already dealt with the issue a few months earlier. Not only did the Rijksgericht decide on electoral rights matters, but Parliament itself was competent to rule on the legitimacy of its members and therefore held exclusive authority to validate elections. The system that reminds us probably to the Dutch case we heard earlier on. The situation back then escalated. Parliament, motivated by political interests, confirmed the elections. The Rijksgericht, however, reached the opposite conclusion, finding that individuals had been wrongly included, violating the complainant's right to vote. This public clash triggered a huge debate among legal scholars. Georg Jelinek argued that only independent courts, not political majorities, should rule on electoral disputes. He saw a structural danger that parliamentary majorities might manipulate electoral processes to their advantage. After the foundation of the Austrian Republic in 1918, the Austrian Constitution has transferred responsibility for electoral oversight from Parliament to the judiciary. Today, both the protection of individual electoral rights and the review of election results both fall within the jurisdiction of the Constitutional Court, but the structural conflict between safeguarding individual rights and preserving institutional stability continues to shape the legal framework. Austria's system responds to this challenge with what I call a dual-track approach to judicial electoral protection. The first track focuses on protecting individual rights, primarily through legal remedies in relation to the electoral roll and the permanent voter registry. In Austria, as in most democracies, only those included in the electoral register are entitled to vote. Citizens have a legally protected right to be correctly entered into the register. If electoral authorities make mistakes, individuals can challenge those errors first through administrative remedies and ultimately before the Constitutional Court. The second track concerns the review of election results themselves. Here, a different model applies. Only political parties participating in the election have standing to challenge the outcome before the Constitutional Court. Individual voters do not have the right to initiate such proceedings on their own. If a political party successfully initiates an election review procedure, a two-step test is applied. First, the Constitutional Court examines whether legal violations occurred during the electoral process. Second, the court assesses whether these irregularities could have influenced the election outcome. Only when both conditions are met, the court orders a partial or a complete repetition of the election. At first glance, this system appears to limit individual legal protection. However, these limitations do not necessarily contradict a rights-based understanding of democracy. The Austrian constitutional system is based on the idea that individuals alone do not constitute a democracy. As Hans Kelsen put it, those who disagree with the prevailing social order must, quote, find a majority so that they, as individuals, may once again be free. That means individuals need to join with others, to organize and act collectively in order to have a real democratic impact. This understanding has shaped both Austria's democracy and its system of subjective rights. In the late 19th century, new forms of collective identity began to emerge: religious communities, national minorities, and political interest groups. With them came new legal rights, the rights to assemble, to associate, and to act collectively. Today, the legal system recognizes that certain subjective rights can be exercised only by collective actors. Seen in this light, limiting the right to initiate election reviews to political parties is simply a reflection to the collective dimension of democracy and not necessarily a contradiction to a rights-based understanding of election law. However, the question remains, does this system and this idea also meet international legal standards for the protection of individual voting rights. Particular attention has to be paid to the European Convention on Human Rights, which holds constitutional status in Austria. Since its judgment in Mathieu Mohin and Claire Fayet versus Belgium in 1987, the European Court of Human Rights has developed a comprehensive body of case law under Article 3 of Protocol number 1, with several hundred decisions on electoral rights to date. From this extensive case law, we can derive key human rights standards for the protection of individual voting rights, and also important requirements for safeguarding the stability of election results. Under Article 3 of Protocol number 1, member states not only have to organize elections, they also have a positive obligation to ensure that the entire electoral process is free from arbitrariness. This obligation doesn't end on election day. It applies also to the review of election results. In a key judgment from 2010, the European Court of Human Rights emphasized that, quote, the existence of a domestic system for effective examination of individual complaints and appeals in matters concerning electoral rights is one of the essential guarantees of free and fair elections. Without such a system, the rights guaranteed by the Convention would be meaningless. The court reaffirmed this in later rulings, most notably, as we have already heard before, in Mugemangango versus Belgium in 2020, a ruling by the Grand Chamber of the court. The Grand Chamber in this decision made clear when serious and credible violations are raised, the state must provide an effective complaints mechanism with safeguards like impartial review, legal standards, and fair procedures. At the same time, states have a margin of appreciation in how they design their systems. How much discretion they have depends on how serious the alleged violation is, and also on what kind of voting right is at stake. The European Court of Human Rights also requires that national election review mechanisms must make it possible to partially or fully annul election results if serious irregularities occurred. At the same time, the court demands that the annulments are not imposed lightly. Cancelling an entire election because of minor issues that had no effect on the outcome would itself violate the right to vote. That's why the European Court of Human Rights insists on a substantive examination. Courts must assess whether the alleged irregularities were actually capable of influencing the outcome. However, this does not mean that courts can dismiss complaints without proper scrutiny. Even if an irregularity turns out to be irrelevant to the final result, the court must still examine the specific claims in detail. Simply assuming that the outcome wasn't affected without careful reasoning would fall short of the Convention requirements. Let me now conclude with an evaluation of the Austrian system in the light of the Strasbourg case law, and with a broader reflection on what this reveals about electoral rights protection in constitutional democracies. Austria's dual-track approach, combining individual remedies in voter registration with a review procedure limited to political parties, represents a conscious attempt to balance two core objectives: the protection of individual electoral rights and the stability of democratic institutions. Some elements of this model clearly align with the standards of the European Court of Human Rights. Most notably, the Constitutional Court applies a two-step test. It first examines whether a legal irregularity occurred and whether it could have influenced the outcome. This sequence is not only compatible with Strasbourg case law, it is explicitly required. More contentious is the exclusive standing of political parties in the election review procedure. This restriction reflects Austria's party-centered democratic tradition and is, in principle, tolerated by the European Court of Human Rights within a state's margin of appreciation. But the court has also made it clear, serious electoral violations must be open to legal challenge by individuals. In Austria, such individual remedies exist only in limited contexts, primarily before the election when it comes to errors of the voter register. Once the vote has been cast, avenues for individual redress are very narrow, and this raises questions under the convention system. The Austrian case study highlights a broader challenge. Across democratic systems, there is a structural tension between ensuring meaningful individual legal protection and preserving the functionality of electoral systems. This tension must be addressed within specific institutional contexts. Democratic systems respond to this challenge in different ways. Austria relies on party-based standing and outcome relevance requirements. Other systems may rely on other instruments. Here we can identify potential for further comparative research. Which institutional designs best guarantee electoral rights without undermining the legitimacy of elections? With which procedural models offer individuals meaningful access to justice without opening the door to strategic or destabilizing litigation? In times of growing pressure on democratic institutions, understanding the tools that maintain its credibility, resilience, and fairness will only grow more important. I'm interested in hearing from the mechanisms and systems that you are familiar with during the following discussion. And for now, I would like to thank you very much for your attention.
Thank you, Max, for the presentation and for the perfect use of time too. And then I'll ask Joseph Claver to do the presentation, to introduce your paper.
Great. I will share my screen now. Let's see. Can you see my, can you see the slideshow now?
Yes, we can.
Okay, great. Yeah, so I just want to reiterate what I've heard from other panelists and thank the organizers of this conference and the chair and the discussant for taking the time to give valuable feedback. I apologize that my paper wasn't posted. I thought that I had done that. I'll try to fix that in the next day or so for prosperity. But in any case, so happy to go last. There's a lot in my presentation that will touch on some of the things we've already been talking about. But this project is related to, is a comparative look at how institutional design is related to election dispute resolution, both in terms of how frequently these types of cases are brought and in terms of how they're ultimately adjudicated. Oh, okay. So as we've heard, and as I don't really feel like I need to sell everybody on here, contentious and disputed elections are not rare. They're a relatively common occurrence throughout the world. And as we've seen, there's a need for some sort of institutionalized mechanism to deal with these contests when they do occur. And this is an important part of electoral integrity as sort of defined in the political science literature, as well as the way that it's been conceptualized in various legal documents as well. However, as we've seen, there is, outside of some very broad insights on institutional design, there's not really very specific agreement on the most effective means of doing this, as we see that it's very different throughout the democratic world. To that end, right, there's very wide variation in how these EDR, election dispute resolution institutions, are employed and designed throughout the world. And this is both at sort of at the higher level in terms of what sort of institution is responsible in the first place, whether it's a legislature or a constitutional court, some sort of specialized electoral court or something else, as well as at the micro level in terms of who has standing to complain, whether individual voters are allowed to, whether it has to be a candidate in the election or a political party, whether there are fees associated with filing a complaint, etc. Okay. Right. So I argue, and the thing, what I look at in particular in this paper, that two types of design factors are particularly important in terms of how frequently we see disputes and how frequently results are actually canceled. In particular, I find that accessibility, which by which I mean whether or not individual voters have access to the process themselves or whether it has to go through a political party. Accessibility can also relate to In this paper, I focus more on standing, but another example of an accessibility-based problem that I want to look at in later work is related to fees associated with filing, because in some countries it's actually quite expensive. And the partisanship of the body tasked with actually making the decision. That is, whether the people tasked with this are directly elected in a partisan way, as they would be in a legislature, or whether there's at least a sort of no official partisanship, and when they're appointed, as in sort of whether these things go through normal courts or through a constitutional court. As we've seen right in a past presentation here, judicial ideology is clearly important. And so I don't mean to say that just because these disputes are resolved in a court that partisanship plays no role. However, I focus here on whether the institution is explicitly partisan. Okay. So to that end, like a good comparativist, I have a two-way typology here that I've created. And we can see in that essentially my theory, put very simply, is that in high accessibility institutions, that is where voters are allowed to file disputes, I expect that we'll see more disputes as compared to low accessibility institutions, where they have to go through, where individual voters don't really have the capability of lodging disputes, whether, again, because of, I mean, I've focused mostly on standing here, but it's actually the full definition focuses both on standing and cost. Apologies that wasn't clear. On the flip side, as it relates to partisanship, I don't see the partisanship of the institution being as influential in terms of the number of disputes, but in terms of how frequently results are canceled. In that, because, I mean, again, as we've heard in some of these past presentations, in a high partisanship environment where it's being decided on by a legislature, the question of partisan bias is sort of always is omnipresent. There's like always going to be concerns about this. Whereas in a low partisanship environment, such as in a constitutional court, my argument is that these institutions are more free to actually cancel elections given disputes. Okay. So to that end, in terms of like mapping these specific the typology to the cases that I focused on in my paper, the sort of in the upper left corner of a high partisanship and high accessibility case, I look at disputes in Germany, where they're mediated by the Bundestag. At least as in the first case, they can then ultimately be appealed to the Bundesverfassungsgericht, but they do start in the Bundestag. The other high partisanship case I look at, the German system is also very accessible because regular voters can file disputes and there's no fee associated with filing. In the US, it's also a sort of what I would call a high partisanship case because it's also done within the legislature itself. I mean, again, the US case is a little complicated in that there are sort of shifting norms and the courts are certainly involved in these cases sometimes, but ultimately the Constitution is clear that the House is in charge of determining its membership. If you look at the Federal Contested Elections Act, it similarly the House is can decide in this. Now, granted, the House also defers to the courts in many ways, but again, we can talk more about that later. But it's low, in the US case, it's low accessibility in that voters cannot directly file disputes, even though there's no sort of fees associated with this process. On the low partisanship side, I look at France and the UK, where in France, it's handled by the Constitutional Council, and in the UK, it's handled by a High Court panel. And in France, it's a very accessible process where voters and candidates are free to file and are both allowed to file and it's free. Whereas in the UK, there are significant fees and deposits associated with the process. So I see that as being less accessible. So I'll move on to just some descriptive data about how frequent disputes are in these various countries. So first, we're going to look at Germany. So this is a graph of the number of disputes filed by citizens and candidates since 1949. And we can see that they are quite common, especially after reunification. After every single election, there have been some number of disputes, and frequently there are hundreds, if not thousands, with the election in 2021 being the sort of high watermark due to significant issues in Berlin, which I'll talk about more in a second. And so based on my expectations of a high number of disputes, we can see that, I mean, again, in a comparative case, there are few countries that have anything even close to this number of actual like formal election disputes filed. And in terms of cancellations, though, despite the frequency of disputes, the first sort of results cancellation in the history of the Federal Republic happened regarding the 2021 election in Berlin. So disputes themselves are very frequent, but actual results cancellations are quite rare because of again, related to the sort of criteria that we've talked about we've heard about before in terms of was there some sort of electoral wrong and did that wrong actually influence the result? And that's the latter of those criteria that is sort of the largest hurdle. Next, we'll look at this is actually, I'm sorry, this is a different graph than appears in an updated version of the paper. Sorry, where I've organized it differently, but suffice it to say that we can see that there are there are quite a bit. Disputes are much less frequent in the U.S. case. And during this time period, there were actually no cancellations. So again, it's due to its inaccessibility and partisanship. I see that as depressing both the number of disputes and the number of cancellations. Also, I do apologize that this is the wrong slide. The correct slide is in my paper, which I'll post later. In France, we see it's in some ways similar to the German case in that disputes themselves are quite frequent and also frequently number, in the hundreds. In particular, this is driven by a change in as part of election campaign finance reform in the late 80s and early 1990s that created a new institution that could basically challenge the candidacy of candidates who had violated France's campaign finance laws. However, unlike Germany, cancellations are also quite common in the French case, in that basically in the aftermath of each of these elections, between 2 and about 8. I mean, it varies from election to election, but over this time period, there have been dozens of individual district level elections that were canceled and required a subsequent by-election to remedy. So again, while there are actually fewer disputes than what we see in Germany, the rate of cancellations is considerably higher. Actually, I have to apologize again. I think that the US slide was in fact correct. I was getting it mixed up with the UK slide, which was the one that I had to change. But in any case, this one is also correct. So I believe that there aren't any mistakes here, but I'll double check later. It's right in the paper. That's what I know. But in any case, what we see here in the UK, where it's inaccessible but low partisanship, disputes are even less frequent than in the US. However, in this time period, there have actually been cancellations, unlike in the US, requiring a by-election. So this is sort of consistent with my expectations. And so, obviously this is just a at the moment a very like qualitative look. So I'm open to alternative explanations that people want to propose. In the limited amount of time that I have left, I'll sort of talk about, I have some sort of individual election case studies that I think are also illustrate these factors. So in the case of Germany, right, just as a reminder, it's like high accessibility, but high partisanship. So we see a lot of disputes and low cancellations. So the 2021 Bundestagswahl in Berlin was plagued by huge issues. I won't go into them here. There were around 1,000 disputes just filed about this, and including there were also other disputes. And this is for the first time we see actual canceled results. However, if you look into the like records of like the debate surrounding this in the Bundestag, so it's deeply controversial and accusations of partisanship were rampant from both opposition parties that wanted to redo the election in Berlin in its entirety. Obviously, government parties that had won the most seats wanted a more limited like redo of the election. Next, talk a bit about France, right? In France, in Hérault, in the 6th constituency in 2012, it's a very close election decided by only 10 votes. The Constitutional Council received numerous complaints about this, including one from the losing candidate. And unlike the case in Berlin, the council invalidated this result without controversy. And again, I have to emphasize that this is quite common in the aftermath of French elections. In the US, right, we see very different than the case in France. In the Iowa 2nd in 2020, this was an even closer election decided by just 6 votes. The losing candidate actually decided not to even pursue this case in the House after pressure from both Republicans and Democrats that this was, this wasn't the proper way of doing things, even though, I mean, from a legal perspective, you can argue that it might be better to go through the courts and just then defer to the courts. But from a legal perspective, there's absolutely nothing wrong about going through the House of Representatives. And so again, despite how close the election was, there was actually no challenge here. The last case, and apologies for really like rushing through these, is the UK, where in Northeast Fife in 2017 was a House of Commons election that was decided by just 2 votes. And similar to the US case, right, we don't even get a dispute here because the losing candidate and their party opted not to. And in fact, if you look at press releases, they explicitly mention the cost concerns associated with filing a dispute, despite the fact that, I mean, this was after there were multiple recounts where, first one person was ahead, then another person was ahead, and ultimately shifting 2 votes in this type of the dispute resolution procedure is, much larger margins than this are routinely canceled in France, is how I'll put it. And so in any case, I'm out of time, and so I look forward to some comments. Thank you.
Thank you, Joseph, for the presentation. Then thank you for all the panelists to present your paper and your research. Now I'll ask Rodrigo Martins, our discussant, to lead the discussions and say your comments of the papers.
Thank you, Carol. Good morning, everyone. Let me control my time here. So it's an honor to be in this panel on a topic that the very heart of a democratic governance. And I should note that my comments today have been prepared based on 3 papers sent by our panelists. Unfortunately, I did not receive all the materials for the session. With that said, I want to start with the idea that an election dispute isn't a system failure, but its most rigorous test. So the way democracies build their architecture of containment to manage these conflicts reveals their priorities, their strengths and vulnerabilities, right? So the papers we'll discuss today offer complementary lenses to examine this architecture. What unites them is the core idea that electoral justice is a battlefield of conflicting values. So Blesnik's papers takes us to the philosophical roots of the problem, right? So the tension between individual and collective, the Austrian dual track model he describes illustrates this choice. It prioritizes the finality of the result, forcing us to ask what the cost is for perceived legitimacy when a citizen is told their violated right doesn't matter, right? Next, Claver gives us a comparative map of this architecture, mapping the trade-off between access and impartiality. So his typology shows a crucial dilemma: highly accessible systems like Germany's, or less partisan systems like France's, that are far more likely to actually annul elections. So the choice seems to be between hearing everyone or punishing decisively. And finally, Lieber's work on Netherlands put us on the front lines of a global transformation, the tension between parliamentary sovereignty and judicialization. So we see in real time a century-old system being forced by a supranational court to hand over the keys of electoral validation to the judiciary. However, these models operate on assumptions that feels increasingly fragile today. Two shadows loom over this debate. The first is the strategic design of the rules, which forces us to ask an uncomfortable questions. Are these institutions designed for systematic stability or to protect the interests of established parties by limiting political competition? And the second, and maybe more important, is the lawfare question. Using litigation as a weapon to delegitimize process. So this turns the virtue of accessibility into a critical vulnerability. And the collective contribution of this panel is to show that resolving election disputes isn't a technical choice, but it's a battlefield of values and political strategies that leave us with a few questions to guide the discussion here. So, what fundamental values should guide our architecture of containment? Should we protect each citizen's subjective rights, where every complaint is valuable? Or should we prioritize the stability of the collective results, where only the macro impact matters? A second question is, how then can we design systems that are both open to legitimate complaints and resilient to bad faith attacks? And finally, what builds more public trust? A system that promises to hear everyone, or one that demonstrates the power to act? So with these thoughts and questions, I'll now turn to the individual papers, and my approach for each will be to offer a brief suggestion for the research, and then pose some questions to stimulate our discussions. So I like to start with Clever's paper. This is a valuable contribution, his elegant, intuitive 2x2 typology, focusing on accessibility and partisanship. So Clever simplifies a complex world and generates clear and testable hypotheses. So to push his excellent work even further, I would suggest three paths for development. So the first one is about the theoretical engagement. I think the analysis would be even richer if it engaged with a broader theoretical framework, like the principal agent theory. So it could provide an explanatory engine for why systems are designed so differently. So delegating to a court could be seen as a credible commitment, while keeping power in the legislature is a case of self-agency with potential legitimacy costs. The second point is refining some concepts. So the concept of partisanship defined structurally could be enriched by acknowledging its other facets. So like the behavioral partisanship and perceptual partisanship, both of which you already surface in your case studies. And the third idea is about electoral integrity. Another avenue worth exploring is connecting these findings to the literature on electoral integrity, like the work of Pippa Norris. So this would strengthen the normative implications, as the choice between a release valve model like Germany's and a show of force model like France's has direct consequence for public trusts. And I have three questions for debates based on your page. So you set up partnership and accessibility as a trade-off, but our cases suggests an interaction between both. So isn't the high accessibility in Germany precisely what allows the partisan system to absorb discontent without ceding power? And isn't the low accessibility in UK what protects the judiciary's legitimacy? So could you elaborate on that, on how these dimensions might reinforce each other? The second question is, you frame the reluctance in the Iowa case as institutional forbearance. But could this also be seen as a strategic partisan calculation by the Democrats to avoid accusations of hypocrisy rather than deference to an abstract norm? And third, based on your findings, what advice would you give to a new democracy designing its system? Should it prioritize mass participation through high accessibility, or decisive oversight through a higher rate of annulment? So now turning to Blesnik's paper. This paper is what makes this article original is how it frames the debate within the dichotomy of subjective right versus objective law. So the description of Austria's dual track system is clear and reveals a fundamental political choice about the nature of democracy itself. So to broaden the paper's impact beyond this single case, I have three suggestions. The first one is about the contextualization in political science. So the paper would be even more powerful if it engaged with theoretical debates in political science. So the Austrian story is a classic example of judicialization of megapolitics. And the discussion on legitimacy would connect directly to the work of electoral integrity. Like I said, like the Pippa Norris work. So this bigger contextualization will let you ask whether a system that prizes stability over individual access might erode perceived legitimacy. A second suggestion would be to go deeper in the party theory. So your justification for the central role of parties is very thought-provoking, but it could be made even more robust by challenging it with the party cartel thesis by Katzenmeier. So this critical lens would force the question, does the Austrian system promote pluralism, or does it help entrench established parties against new challengers? And third, I think the strength of the case study would be amplified by a comparison with other models like Germany's, which is broad in individual access, or like Spain's with the recurso de amparo. So this would highlight that the Austrian solution is a choice and not an inevitability. And some questions for you to debate. The first one is about the core trade-off. In contrast to the German model, doesn't the Austrian approach risk winning the battle for formal stability, but losing the war for perceived legitimacy? So can a system that tells a citizen that their complaint is legally insignificant truly sustain public trust? The second question is, how do you reconcile the view of parties as legitimate collective actors with the party cartel thesis? In practice, isn't the Austrian system creating a legal barrier that protects established parties from challenges by new civic movements or something like that? And the third question would be, your framework seems well suited for traditional administrative errors, but how would it handle modern threats like a deepfake disinformation campaign that doesn't alter the vote count but violates the right to an informed choice? In that scenario, doesn't the lack of a robust individual remedy become a critical systematic failure? And finally, I'll address Loeber's paper on Netherlands. So the detailed legal analysis of Dutch systems in light of the recent ECHR decision is clear and very convincing, and you show exactly why the reform has become an imminent legal obligation. So to elevate the paper from an excellent case study to an even broader theoretical contribution, here I give 3 suggestions too. So the first one is make an explicit theoretical framing. So the theme of judicialization of politics is implicit, but I think it should be made the central, a more central theoretical frame. So the Dutch case is a perfect example of externally driven judicialization, where a supranational court forces a question that was purely political to become a judicial one. So analyzing it through existing theories would turn this discussion of institutional design into a deeper analysis of political power. The second suggestion is a dialogue with comparative law about lawfare. So your analysis would benefit from a dialogue with the experiences of other democracies, especially about the rise of electoral lawfare. So the Dutch reform, I would say that it's not happening in a vacuum. So the challenge isn't just to meet ECHR standards, but to build a system that is robust and resilient to strategic and bad faith attacks, in adding necessary layer of political risks to the legal discussion. And the third point is, again, to add some comparative analysis. a brief comparative analysis would be useful. No? So a comparison with system like Germany, that it's a hybrid model, or Sweden, that is more specialized quasi-judicial body, will help visualize the trade-off of the Dutch reform options. So the German model offers a path of partial judicialization, while the Swedish one presents an interesting middle ground. So these contrasts help illuminate the specific choices that Netherlands now faces. And to end my talk, I have 3 questions for you for the debate. So recent experiences show the rise of electoral lawfare. How would the reform models you propose hold up against a coordinated bad faith attack designed not to correct errors, but to overwhelm the system and sow distrust? Is a system designed for good faith disputes inherently vulnerable? And what specific safeguards like fees or standing requirements should be considered not as a barriers, but as a necessary institutional defense? The second question is, this transfer of power to the judiciary is a fundamental political choice. So in your view, what is the optimal point of judicialization for a consensus-based system like the Netherlands, especially in a political climate that is becoming more polarized? So how do you weight the risk that a more powerful judiciary could undermine rather than strengthen the democratic legitimacy in that context? And finally, where would you draw the line on the scope of electoral justice? Should complaints about the fairness of the campaign itself, like disinformation, unequal budgets, be grounds for annulling an election, as has been debated in other European contexts? Or wouldn't opening the door invite a near infinite judicialization of politics, turning courts in the final arbiters of political debate itself? So with that, I'll conclude my comments, and I thank again for